My name is Marcus Harris. I'm a Chicago-based software and intellectual property attorney. Since 1999, I focused my practice on drafting and negotiating ERP-related contracts and litigating failed ERP implementations in courts across the country. Prior to forming my own practice, I worked in the legal departments of SAP and Infor. I understand how ERP vendors work, and I understand what it takes to sue ERP vendors for failed implementations. Now, one of the causes of action we typically bring against an ERP vendor for a failed implementation is a claim for fraudulent inducement. And one of the strategic reasons we do this is typically ERP vendor contracts are one-sided. They contain onerous disclaimers and limitations of liability that really don't provide much relief. Now, if proven, a claim for fraudulent inducement can allow you to recover damages in excess of the limitations in the contract. To establish fraudulent inducement, you typically need to prove that the vendor made a misrepresentation of material fact, that the vendor was aware of the falsity of that representation when it was made, and that the vendor intended to induce you into the contract with the vendor. Now, while that sounds relatively straightforward, it's actually difficult to prove. And one of the things that we do in order to ascertain the viability of bringing a fraudulent inducement claim is to hire a third-party software implementation expert, and they will review implementation documentation from the sales cycle and help us to make a determination as to how viable the claim is and whether it makes sense to move forward with a lawsuit asserting a claim of fraudulent inducement against the vendor for the failed ERP implementation. Now, if you have any questions about any of the issues in this video or any of our other videos, please feel free to give our office a call at 312-263-0570. Thank you.